Hello everyone, I am Rashi Goel and I am pursuing BLLB from University of Petroleum and Energy Studies, Dehradun. And currently I am a legal intern at LEXIS and Company for the month of June. So the topic for my today's video is Quasi Contract. The obligation arising out of quasi contract was first recognized by the English law. The Indian Contract Act 1872 also followed the same elements which are followed by the English Contract Act. There is no definition given for the quasi-contract in the Indian Contract Act. But the Act states that it is the case of a quasi-contract. Certain relations are created which are very similar to the contract. But quasi-contract can be defined as a set of rights and liabilities between the parties even when there is no formal contract. The law creates the obligation to maintain the justice and fairness between the parties. The law does not allow one person to enrich himself at the expenses of the other. If the rights and the obligations are not created, one party would be unjustly enriched. Going by this, it can be said that the quasi-contract is a kind of a remedy instead of being a pure contract. The formation of a quasi-contract allows the aggrieved party to recover the benefit which the enriched party has taken at his expense. Since a quasi-contract is a law made by the law, there is no statement of consent between the parties. The obligation and the right which are placed on the shoulder of the parties are rather by law than by the assent. Many times, a situation may arise that a legal obligation is placed on the person to uphold justice, even though the person has not committed any tortious activity or has broken any contract. Let's take one example. Suppose X forgot some good at Y's place. Y is under a legal obligation to restore the good. This goes on to show that Y cannot enrich himself at the expense of X. Such kind of obligations are described as quasi-contractual obligations. They are not actual contract in which the parties agree to enter, but are the fictional contracts or agreements which are created between the parties by law so as to ensure the equity. Also, the liability in the case of quasi-contractual obligation is based on the principle of unjust enrichment. It essentially means that no man should get unjustly enriched at the cost of another person's loss. That means no person should gain anything unjustly, when his gaining such a thing may mean loss for the another person. Now, let's discuss the features of quasi-contract. First is implied in fact contract and quasi-contract. One of the main features of quasi-contract is that there is no mutual consent between the parties. Quasi-contracts are often confused with implied in fact or implied contract. The difference between quasi-contract and an implied contract is that in the case of an implied contract, even if there is no written statement of the fact that the parties want to enter into a contract, their actions and conduct imply that they have mutually agreed to enter into a contract. For example, P goes to a restaurant for a dinner. The owner of the restaurant expects P will pay for his food. P also knows that he will have to pay for the food which will be provided by the restaurant. Thus, the action of the parties signify that they have mutually agreed to enter into an agreement even though the agreement is not written one. Next is section 68, that is claim for the necessities supplied to person incapable of contracting or on his account. if the necessities for a person who is incapable of contracting, for example, a minor or a mentally disabled, or of the dependents of such a person are taken care by someone else, he has the right to be reimbursed from the property of such incapable person. Although the word necessaries has not been specifically defined in the Act, it is impliedly clear that it means necessaries to sustain life, food, basic things, clothing, education, etc. There are things without which a person cannot reasonably exist. Let's take one example. If a person A supplies another person B who is incapable of entering into a contract, or his family or anybody else who is dependent on him with the necessaries for life, he is entitled to take his due return from the property of person B. He is entitled only to such reasonable amount as the value of the goods or the services he may have supplied hold. Next is section 69, that is reimbursement of person paying money due by another, in payment of which he is interested. Suppose Ram pays something in Amit's place, that which Amit is himself bound by law to pay. Ram will be reimbursed by Amit. Here it is important to note that Ram should be interested in this payment. It is a case of implied indemnity, and Amit, whose payment is due, was in fact bound by law to pay. Now let's further talk about section 70, that is obligation of person enjoying the benefit of non-gratuitous act. When a person lawfully does something for another person without intending to do so gratuitously, and the another person enjoys the benefit of such good or service, then the latter is bound to pay back for the former. For example, suppose someone's Amazon package mistakenly got delivered at your address. A pack of chocolate chips cookies that you ate as soon as they arrived. You are liable to compensate the actual owner of the package. Next is section 71, that is responsibility of the finder of the good. Simply, a person who finds goods that belongs to another person shall be treated as a bailee. A bailee is essentially a safekeeper of the good who is supposed to return the goods to the actual owner or dispose of them in the manner in which the actual owner may want them to. For example, Sarah finds a diamond lying on the floor in a shop. She picks it up and keeps it in her safe possession. Sarah makes all reasonable efforts to find the true owner of the diamond. The diamond actually belonged to Ananya. Sarah has right to hold the possession of the diamond against the whole world except Ananya, and is supposed to make reasonable efforts to find her and return it to her. In this case, Ananya will have to pay the compensation for all the loss suffered by Sarah in finding her. And last is section 72, which talks about the liability of a person to whom money is paid or things delivered by mistake or under coercion. If something is delivered to a person by mistake or under coercion, he is liable to pay it back. For example, Sarah and Ananya share a flat and contribute in half for the rent to be paid. Sarah, without knowing that Ananya has already paid due rent to the landlord in whole, pays to the landlord. The landlord in this case is liable to give back the money delivered to him by mistake. The term mistake here can mean both mistake of fact or mistake of law. Or suppose a railway company refuses to deliver goods to a certain customer except upon the payment of certain illegal sum of money. the customer pays some of the money to obtain his good. The company is liable to return the sum of money illegally charged. Thank you everyone for watching my video. I hope you like it, and if you did, please give it a thumbs up and share it with your friends and family. And don't forget to let me know your feedback in the comment section. Stay home, stay safe, stay healthy.